In today's video, we're going to talk about the FDCPA debt validation requirements. Debt collectors, it doesn't matter if they are working for the original creditor or if the debt collector is collecting the debt for debt that they've purchased from the original creditor. They all have to go through a debt validation process if you request it. Now, the number one reason why a lot of debt validations slash verifications are disregarded by debt collectors who are either collecting debt for debt that they've purchased or collecting debt for the original creditors who have hired them to collect the debt is because the sequence of requesting a documentation is out of order, or you haven't properly put together your debt verification slash validation letter to the debt collector who is trying to collect the debt from the original creditor, or from their own company where they purchased the debt from the original creditor. If you get this right, and part of getting to know what you're doing right or wrong is to understand what the rules are according to the Consumer Financial Protection Bureau when it comes to doing a debt validation, also with the Fair Debt Collection Practices Act. Now, both of those mirror each other. Really, when I review the changes that were done by the CFPB, you could say, if you can imagine this, the CFPB tries to do updates to the way that debt collectors are relating to consumers based off of the lawsuits and the problems that are happening day to day, year to year. The FDCPA is what Congress enacted as a law, and that has to be updated and voted on. So what the CFPB does is when they start to see issues that are happening that are probably covered in the Fair Debt Collection Practices Act, but because when something happens, it's not always by the book, they'll make adjustments, and then they'll say, well, we want to give guidance on the way that debt collectors must proceed when trying to collect debt from consumers, because there's a lot of violations that happen because it's not written in, it's a gray area in the Fair Debt Collections Practices Act, the FDCPA. It's gray. It's there, but it's like a gray area, and because it's not fully defined by the way that you've probably been affected by a debt collector, it's a gray area, and debt collectors can kind of lean on that and say, well, we didn't violate it according to the Fair Debt Collections Practices Act by the book. And so they can get away with it. And until that happens to a lot of people and then they do a class action, a lot of times it goes under the radar for those violations. But from what I've seen with working with thousands of clients is that the number one reason why debt validation slash verifications don't get the attention that it should get from debt collectors is because of either it's been out of order, and what I mean by out of order is that you're asking for a debt validation at the wrong time. Here's an example. What would be asking for a debt validation at the wrong time? Say that a debt collector is suing you in court. It could be from the original creditor or a debt collector or a debt collection company that has purchased the debt. And I've seen people send a debt validation letter to them while they're in the middle of a court proceeding. And some of the times they will respond and send you some documents and send you some stuff, but it's out of order. And they can actually just disregard it and not even do anything about it because you are not responding to the court summons. You can actually put the debt validation inside of your affirmative defense for the court summons. So if you do it out of order, you're giving them permission to not do anything about what your request is. The other thing The other thing that tends to happen is that people just don't respond to the 30-day letter that the debt collector sent to them. And by the book of the CFPB, if you do not respond within that 30 days, they're allowed to proceed with everything as if it was true according to their records. Now, yes, there are things that you can do about it moving forward, but you've already given them a leg up on dealing with you. Because if you don't respond in that 30-day period, they're allowed to put that information on your credit reports. They're allowed to proceed as if everything that they have according to the debt that they've either purchased or that they're attempting to collect for their client, the original creditor, is 100% true and accurate. So be aware that when dealing with debt collectors, it doesn't matter with the original creditor or a debt collector who has purchased your debt from the original creditor, you need to follow the steps to make sure that, number one, if you end up having to pay that debt, that they have proven everything and you make that decision if you're ready to move forward with a settlement. If you're dealing with, and that's what's the original creditor, if you're dealing with a debt collector, you want to make sure that they go over and above, and then according to your own personal goals, you can decide on if you want to do a settlement with that debt collector or if you would want them to go even further to prove that they can collect that debt from you. Now, before I get started on what needs to be in a debt validation, or the requirements of a debt validation, I'm making the assumption that the debt collection that is either from the original creditor or a debt collector who has purchased your debt, that debt is not past the legal statute of limitations. So moving forward in this video, I'm assuming that the debt that we're talking about is not past the legal statute of limitations to collect. All right, so moving forward, the FDCPA, I'm looking at my notes here. The FDCPA debt validation requirements. FDCPA provides the following debt validation requirements. This pertains to any debt collector who is trying to collect a debt. Debt collector attempted to collect a debt for themselves or for the original creditor. So within 5 days of the initial communication with the consumer, the debt collector must send a written notice, also known as validation notice, containing the following information. So this would be as if a debt collector called you on the phone. You answered, you're like, hey, is this Steve? And yes, this is Steve. And they say, well, we're calling from such and such company, and in an attempt to collect a debt for themselves or attempt to collect a debt for the original creditor. But they want to do all their verification that you are the proper person because they don't want to reveal the information to someone else. So they call you up and they say, okay, yeah, this is me, but I'm not familiar with this debt. I'm not familiar with you. Send it to me in writing. If you've watched my older videos, I always said, get a call from a debt collector. If you want to deal with this like head on to get this over with, what you should do is you just tell them, send it to me in writing. I don't know, I need you to send it to me in writing. So what they have to send, the amount of the debt, the name of the creditor to whom the debt is owed to. Now, if it's purchased by them, they're going to put the original creditor and the last 4 digits of the account number. But they have to state that they've purchased the debt. They can't play this game that they're trying to collect the debt for that original creditor when they've purchased the debt. Next thing is a statement that unless the consumer disputes the validity of the debt within 30 days after receiving the notice, the debt will be assumed valid by the debt collector. This is the part that I talk about a lot when this is what I'm saying. This is a key word. This is validation. A statement that unless the consumer disputes the validity of the debt within 30 days after receiving the notice, the debt will be assumed valid by the debt collector. So you don't call them back, you don't send them a letter, you don't check a box and send it back saying that this debt is mine. When you don't respond, according to the Fair Debt Collections Practices Act, the way the law is written is that when you don't respond, you say that the debt is valid. Not my words. This is the CFPB and the Fair Debt Collections Practices Act. I'll read it again. A statement, and they have to have this in the letter, but a statement that unless the consumer disputes the validity of the debt within 30 days after receiving the notice, the debt will be assumed valid by the debt collector. That means that they can proceed with trying to collect, they can proceed with trying to sue a person, they can proceed with putting that information on an individual's credit report. That's the way that the law is written. The law is written where when you don't respond, they can assume, and they have a legal right to assume. The next thing is a statement that if the consumer disputes the debt in writing within the 30-day period, the debt collector will obtain verification. So remember, I say the words validation, verification. Obtain verification of the debt or a copy of a judgment, because this could be if a debt collector purchased a judgment debt or they're hired to go after a judgment debt, that they are still required to do that verification of debt, and they mail that to the consumer. The next part in the Fair Debt Collections Practices Act, a statement that upon the consumer's written request within the 30-day period, the debt collector will provide the name and address of the original creditor if different from the current creditor. That goes into if the debt collector purchased the debt, they're going to give that, they have to give you all of that information to prove the chain of custody of how they got the debt and how they even got your information to be able to contact you about the debt. Like, they have to show the relation. They call this a conformity, a notice of conformity. If they purchase a debt, they have to show that chain from the original creditor, bill of sale, other documents that were obtained during the process. And they have to actually disclose that information to you so you can see that. Now, most of the time, they won't give you that unless you use my information. They won't give you that unless they decide to sue you, is when they'll step up that level, because in court, they have to bring more information than just a statement or a bill saying that you owe the debt. So now, moving forward after that, if the consumer disputes the debt in writing within a 30-day period, the debt collector must cease collection efforts until they provide the consumer with verification of the debt and a copy of the judgment. Now, let me tell you how this actually works. And this can frustrate people. I've talked about this before when dealing with debt collectors. When you dispute the debt with the debt collector within the specified period of time, it can put a 90-day hold on that account. So let me tell you some scenarios. Let's just say that you're trying to buy a house and you have to deal with a collection that a debt collector has, and they have it on your credit reports. When you do that dispute with that debt collector, there's usually a 90-day grace period where nothing can be done. They can't contact you. They have to get documents. And the reason why I've seen this be 90 days is because they have so many accounts. And so if you want to settle that account, say that they get you the information, you need to be able to move forward. Even if you call that debt collector, they will not be able to move forward unless you do one thing. You have to attest to that debt. You have to actually take away your dispute, because they're not even allowed to even try to settle that debt during that dispute process. And they don't want to go have any violations. So you'll see where they'll just put it on the shelf for 90 days. Get you the documents when they come in, but they're going to put it on the shelf for 90 days because they don't want to be in violation. So be aware of that. But that on the other flip side of that, if you're trying to buy time to be able to decide on what's going to be your next move with dealing with this debt collector, is that because they're going to shelf it for 90 days, up to 90 days. I've seen 90 days, but it can be up to 90 days depending on the debt collector, depending on their load, their case loads, depending on the amount of work that they have in their office, that it could be up to 90 days, and that can buy you time to be able to decide what your next move is going to be. So now let's talk about the CFPB debt validation requirements, because remember what I said earlier in the video is that the CFPB, because of certain violations that debt collectors have made moving forward after the FDCPA, they will put what's called some guidance rules in effect. And you can say it's like a living document that if they see too many debt collectors doing something, or there's something that's just pure solid violations, even though it's in the FDCPA, but because it's a gray area, they'll make updates to make sure that all of the debt collection companies and law firms that are collecting debt for other for original creditors get this information and make updates to their policies and procedures moving forward when dealing with consumers that have debts that they're trying to collect on. So first, validation of information. Debt collectors must include specific information in the validation notice, such as debt collector's name and mailing address, consumer's name and mailing address, the name of the current creditor, the account number associated with the debt. Now, here's a crazy thing. Even with the CFPB, and this part here goes into where you have people who write these laws that have never had any issues with debt. And even with the CFPB, this is a mistake. I'm pretty sure that they're going to update this in the future. But it says account number, if any, associated with the debt. There better be an account number associated with the debt, because how do you know that that account is valid? How do you know that you're even paying on the appropriate account? But this is what they have, and you can see certain, I would say, I don't want to say mistakes, but where things are overlooked because certain people who write these laws, they've never dealt with this type of stuff before. The itemization date and the amount of the debt on that date. A detailed itemization of the debt, interest, fees, payments, credit since the itemization date. And I've talked about that if you're being sued by a debt collector, that this is the information that you can request so you can make sure that the claimed amount that they're saying that you owe is the appropriate amount for you to be able to move forward if you're going to try to pay it in full or settle the debt for less. You need to know how they got their information, because if you don't know how they got that number, they could just come up with any number. And if that's the way that stuff is going to be done, that we will be going back before the Fair Debt Collections Practices Act, because people could just come to you and say, well, this is the bill that they're claiming that you owe, that we've purchased from the original creditor. Or the original creditor could say, after all of the fees and everything that we've ballooned it up, this is the amount that you owe. There are laws against them doing that, but if you don't even know that you can even question it, they just come to you with one big fat amount. You know, it's like, what do you do? And that's what people find themselves, is that they don't know what to do. And I'm helping you out on what to do. Now, there's a validation notice format. The CFPB has a model for the validation. And if you can look at there was a video I made last week on how a debt, I had a sample of a debt, letter that a debt collector would send out, and I showed you how it has to be formatted. The CFPB, because of the problems that had came about from people getting notices from debt collectors, they said that they want to have it uniform. Now, it doesn't have to look the same, but it had, when they said uniform, they wanted the same information is required in all debt collection notices. It can look different, But they have to have all of the information. They have to have if they're collecting it for them, with the original creditor, who that was, last four digits from their the debt collector's office. It has to have that you have a right to dispute any, all, part. It has on there that the time frame that you have to dispute it by. Like, it has to have all of that information on there to for their requirements according to the CFPB, and that was an update because people were just sending out debt collection notices, or debt collectors were just sending out debt collection notices, and they have to notify you of your rights. Now, I want to talk about some things that happen. So if you can go back and look up one of my videos where there was an issue with Representative Clyburn, United States Congress, did a report on the three major credit reporting agencies, and they had stated that they had failed to even handle disputes and debt validations and verifications for the information that is on individuals' credit reports. So you might be saying, well, Steve, if it's on the credit reports and it's not verified or validated, how can that happen? Because when you send a dispute to the credit reporting agencies, they're supposed to send that dispute to their clients, the debt collectors, or the creditors. Right there, keyword, their clients, their clients, their clients. Their clients are the creditors and the debt collectors who put the information, furnish the information on the credit reports about us. So, Representative Clyburn had a big report where they had showed that the credit reporting agencies were not doing their job. They were just basically throwing away stuff. Just basically just saying, throwing stuff away, saying that it was verified and that information should be on there. Our company does not just solely depend on the credit reporting agencies to do their job. We come at it from both sides. We go to the furnishers, which could be the debt collector or the original creditor, and we come from the other side going to the credit reporting agencies, because that's how you're going to get the best results. But regardless, when you go and look at this report, you could see why it takes a lot of work to repair credit, especially if you have a lot of issues on there. And it may not just be about dealing with the creditor, the credit reporting agencies. It may deal a whole lot more steps with dealing with debt collectors and original creditors. I'm talking about some on the phone type stuff, like some back and forth negotiating type stuff. That's the type of stuff that we do here in my office. So now, here we're in that investigation from United States Congress. Representative Clyburn's report said that there was that the credit reporting agencies, the CRAs, they had a failure to properly investigate disputes. This was what they said. And then they also had automated dispute handling. The CRAs primarily use automated processes to handle disputes, which can lead to inadequate reviews and resolutions. These automation systems may not accurately interpret the specifics of each dispute, leading to unresolved or improperly resolved disputes. We talked about that before in the past. Inadequate response time. CRAs, credit reporting agencies, often fail to respond to disputes within the time frame mandated by law, which is 30 to 45 days. 45 days in most cases. However, reports found that many disputes are not addressed within that time frame, 30 to 45 days. During COVID, they actually had a 60-day window during COVID. Now it's kind of went back to normal to 30 to 45 days. And I know people get frustrated. We hear it a lot. When it gets into their hands, it's in their hands. Even with the report that happened with Congress, with the regulations that Congress have, which the regulations just got cut by the Supreme Court. Well, I won't get into that. They do what they do. Once it gets in their hand, they do what they do, and it is our job or your job if you're trying to repair your credit to stay on them to get the result that you need to get to for your for your credit repair process. They said that because these disputes were not being done on time, it had a huge impact on individual scores, uh, huge impact on making it difficult for people to even obtain credit. So the issues have been heard. Report has been presented. They called all three credit reporting agencies, CEOs or presidents, to Congress to speak on this. And this is what they basically said. Bottom line, I'm just going to sum it up to you. Bottom line, and you can look on my channel for a video. I put a snippet of a video from that hearing, and I believe it was the Equifax, or it was either the Equifax or the Experian CEO said this plain and simple, and I'm going to repeat it to you right now, because if you get this, then you're going to be way ahead on starting to work on your credit. Is that the credit reporting agency CEO, either Equifax or Experian, specifically said it is not up to them to make sure that your credit information is 100% accurate. That was his words. That was his words. So if someone that is in charge of the entire company says something like that, you should take heed and understand that it is not up to them to make sure that your information is 100% accurate. It is not up to them to clean your credit. It is not up to them to do anything but gather information and put it on your credit reports. It is 100% up to us to make sure that everything is accurate. It is 100% up to us to get negative information off our credit reports that we believe is either inaccurate or unfairly describing us as individuals, because they are just data processors. And I don't care if you're dealing with people. I don't care if you're a business owner or whatever. You need to control the narrative about how people look at you, and the way that creditors look at us is by the information that's on our credit reports. So that's what you need to have in your back pocket. Now, I'm going to give you debt validation. I'm going to give you a letter. Don't worry about that. At the end of this video, give you a letter that you can move forward with if you have debt collectors coming after you early in the game for debt that they've either purchased or that they're collecting for the original creditor. No matter what, if you have a debt collection lawyer that is coming after you for debt that they're for the original creditor, you still have the same rights to make that debt collection attorney go through the same process that all debt collectors go through who purchase debt. They still have to do that validation verification process. So if you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process and my 2-phase settlement process. If you need your credit reports and scores, go to the website scores.com. scores.com. Grab your TransUnion, Equifax, and Experian credit reports and all 3 scores. If you have debt collectors coming after you early in the game, grab my 3-pack of letters: statute of limitations letter, debt validation letter, and cease and desist collection activities letter. Use the one that's appropriate for your situation. Thank you for your time. Subscribe to the channel. Post your questions and comments. This is Stephen A. Williams, president and founder of thecreditrepairshop.com. Make it a great day.